The decisions made by the United States Supreme Court touch the lives of everyone in the country. But the people who make those decisions are not elected. They don't answer to voters, they only answer to the law itself. And unless they are impeached, which is extremely rare, they hold their jobs for life. You might assume a position with lifetime authority comes with a massive list of prerequisites. Yet the U.S. Constitution sets 0 requirements for age, 0 requirements for citizenship, and 0 requirements for education. Article 2, Section 2 of the Constitution outlines exactly 2 rules for seating a justice. First, the president nominates a candidate. Second, the Senate must consent. For most of American history, the process was that simple. Up until the 1980s, the Senate confirmed roughly 80% of presidential nominees. Hearings were brief, and a final vote usually happened within a week of receiving the nomination. Today, that quick turnaround is gone. Nominations have morphed into grueling, deeply contentious media spectacles. Because the Constitution left a massive blank space regarding who actually qualifies for a lifetime seat of ultimate power, modern politicians built their own gauntlet of unwritten tests to control the process. The first unwritten rule comes from the White House. Presidents look for a specific judicial temperament, someone open-minded and patient. But more importantly, they look for someone who shares their ideological perspective. A president is only guaranteed 4 years in office. By placing an aligned judge on the Supreme Court, an administration can dictate legal interpretations for the next 30 years. To predict how a candidate will handle controversial cases decades down the line, White House staff dig deep into short lists of candidates, researching their personal backgrounds and heavily analyzing their past rulings. But the president's choice is immediately tested by the legislative branch. The nomination moves to the Senate Judiciary Committee, where outside interest groups begin lobbying senators to confirm or reject the appointee based on their own political goals. The nominee is subjected to days of intense, televised hearings. Senators interrogate the candidate on their personal history, their professional qualifications, and how they interpret the law. It is an exhausting, highly public fight, but this friction is exactly what the Constitution intended: a deliberate, structural check by the legislative branch against the sweeping appointment power of the executive. Beyond ideology, a second unwritten rule has emerged. Presidents now actively try to select a court that represents the demographic makeup of the country. Historically, presidents looked for geographic or religious diversity among a bench entirely made up of white men. In the modern era, that focus has shifted toward racial and gender representation. Look at the composition of the court in 2014. The bench was made up of 6 men and 3 women. Within that exact same group, there was 1 African-American justice and 1 Latina justice. Then there is the final and most exclusive unwritten rule, the elite filter. Remember, the Constitution does not even require a Supreme Court justice to go to law school. Yet on that 2014 court, every single justice attended either Harvard or Yale law schools. Professionally, the modern court is just as narrow. Most recent justices spent their careers exclusively as appellate litigators or law professors, with very little time spent as private practice lawyers or trial judges. The Constitution leaves the highest court open to nearly any citizen. In practice, the modern political machine restricts the applicant pool to a highly predictable, microscopically elite fraction of the population. If a nominee manages to survive the Judiciary Committee hearings, their nomination is voted out of committee and sent to the floor of the entire Senate. At this point, they face their final hurdle. To receive constitutional consent, the nominee must secure a simple majority of the votes cast. Once that majority is reached, the long gauntlet ends. The nominee takes the oath of office and is sworn in as a new justice. Critics frequently point out that this confirmation process has become highly partisan, driven more by the current president's political strength than a sober review of legal merit. But you can also view this grueling ordeal as a necessary democratic adaptation to incredibly high stakes. Because once a justice takes their seat, they can never be fired, and they never have to answer to voters again. This fierce, exhausting confirmation battle is the singular moment the American public has any power to shape the future of their laws.